but also provides states with much needed revenue for other important services to their citizens and residents. But the failure of the federal government to join in this regulatory program has created a vulnerability that may ultimately allow the illicit market to prevail and eventually destroy all of these protections. With that will come all of the ills that so many have worked for so long to prevent. For example, right now, cannabis is a predominantly cash business. That brings with it the real threat of armed efforts to steal the proceeds of the business and the need to meet that armed aggression with armed protection. This is not a recipe for public safety. What is really needed to resolve this and other challenges and threats to public safety is for Congress to act to create a unified regulatory environment that involves both the states and the federal government. With that will come the availability of the prerequisites for normal business: access to banking services, access to capital markets, access to lending facilities, and the ability to fund small business loans to diverse populations to allow them access to the industry. With the recognition that cannabis does have valuable medical applications, the broad legalization of it in the states, we face a simple reality: cannabis will be present in our society. We tried to ignore that reality for decades and to no avail. It is time for us, and in particular Congress, to recognize this reality and to provide the safest and most effective regulatory environment to exist. I am now going to hand it over to Howard Sklamberg for remarks from him.
Thank you, Jim. And I point out that I was Deputy Commissioner at FDA, and one of my jobs there was to be chair of FDA's marijuana working group from 2014 to 2017, in developing the policy FDA had then, and indeed interpreting the Cole Memorandum that Jim issued while in the Department of Justice. So I believe, like Jim, that this action is an important step forward in the rational regulation of cannabis. Its immediate effect when it is finalized would be on the finances and having a rational approach to the taxation of cannabis businesses that, like any other business, they can deduct their legitimate business expenses, which is a very big deal. The analysis, the FDA and HHS analysis is solid. The folks who perform that analysis and who implement what's called the 8-factor test, which is how you look at the health effects of cannabis, are people who've worked on this issue and on controlled substances for decades. And their analysis is based on dozens and dozens of articles and studies. And what's important is that the FDA and HHS analysis noted how the landscape has changed in terms of our knowledge of cannabis since the last time the agencies looked at that issue back in 2015. We have a lot of experience in the states, and the agencies looked through a bunch of conditions that some folks had said cannabis can treat, and they found that cannabis had an accepted medical use for some, but not others. It was a nuanced and judicious approach. Once DEA puts out its rule, and there'll be notice and comment, and then there'll be a final rule, there will be an opportunity for judicial review, and of course, subject to any political changes that occur at the end of the year. However, I will say that the solid scientific foundation makes the likelihood of challenging it in court much lower. And so I'm very much comforted by that. Like what Jim said, I believe that this is an important first step, but not a final step, because rescheduling from Schedule 1 to Schedule 3 does not change cannabis' status in FDA's regulatory framework, which is to say the Food, Drug, and Cosmetic Act applies the same way to a substance that is Schedule 3 as it does to Schedule 1, which means there is still regulatory uncertainty, and we still have a situation where if you're in the cannabis business, you're basically operating under the enforcement discretion of federal agencies and subject to a whole bunch of different state rules. And one of the things for the cannabis business, as with any business, is you really want to know what the rules are. And you want those rules to be clear so you can follow them. And if you have clear rules, that also provides the maximum consumer protection as well. So I hope this will be a first step in a journey that can deal with making a solid regulatory framework, and also with some of the issues that Tahir is no doubt going to raise, who I'll now turn it over to.
Absolutely. Thank you, Howard. And it's a pleasure to be here today, speaking on behalf of the Minority Cannabis Business Association. Also myself as a business owner, as the CEO of Simply Pure Trenton. And first, I'd like to start off by saying, definitely want to thank and commend President Biden for his leadership in moving towards the reclassification of cannabis. Today's an important first step. And what we've all ended up recognizing, for what many of us have known for over 50 years, is we saw cannabis scheduled as a Schedule I drug, with the assumption that there's no medical value and a high potential for abuse. And righting that wrong with rescheduling is recognizing the fact that cannabis does have medical value, with over 38 states in Washington, D.C., currently with medical programs that are helping people all over the country. And so this reclassifying cannabis will be a great step for business owners. Mostly, as already has been mentioned, being able to peel back 280E and the impact that it has on cannabis businesses will be something that's great for the entire industry, but especially for minority business owners who are financially less stable. So being able to not have the 280E will help us to be able to build our businesses and to be able to put money back into our community, which is an incredible thing. We know that the job doesn't stop here today, as what's important is that we fully deschedule cannabis, but this is a great first step and a historic step towards normalizing cannabis, and also repealing some of the stigma that has been faced by the industry. So I'm very hopeful on what this means for the future and how this will positively impact and hopefully lead to the full descheduling of cannabis one day, as it should be. And thank you.
Thank you so much, Tahir. Right now, we'll move over to take questions. If you have a question and would like to ask, please hit the raise hand button at the bottom of the screen. You can also chat a question if that's easier for you. So just go ahead and we'll let everyone queue up for a minute, and then we'll go ahead and be able to put folks on to ask their questions. First question from Tom. Tom, go ahead. You'll need to unmute.
Hi, a question for Mr. Cole. As Congress works to develop this regulatory framework, advocates and stakeholders would like to see the reissuance of your namesake, the Cole Memo. What do you think the opportunities are to expand that guidance to broaden the scope of federal respect for state laws in a new memo? For example, do you think it's feasible that DOJ could agree not to interfere in interstate cannabis commerce?
I think almost anything is possible. Certainly, it's hard for me to speak for DOJ presently, but I think obviously you've got an enormous step forward with the decision to reschedule. It shows an institutional softening of the position, both at DOJ and even more significantly at DEA. It seems to me at this point that the memo I wrote seems to still have some lingering effect. It's always a good idea every 10 years or so to take a look at something and see if it needs to be tweaked and if it needs to be improved and what lessons are learned. Knowing a lot of people at the Justice Department, these are very smart and very able administrators and people who run the department really know what they're doing. I think it's probably likely they will consider the issue and determine whether or not any further guidance is necessary once the rule has taken effect. Hard to predict what it'll be, but yeah, I think in essence, it's usually a good idea to let everybody know where the federal government stands on prosecution and what the guardrails are going to be.
Thank you.
Just wanted to flag a question in the chat from Chris Roberts. There has been speculation that the Biden administration will issue a new Cole memo. Can Jim and other panelists address the necessity of this? And if so, what it would say differently from the original?
I don't know what it'll say differently from the original. Again, I think it would require some study and basically consultation, more importantly, with the states to identify some of the more sensitive areas that they've experienced over the past 10 years. I know some of the issues involve whether manufacturers in creating gummies and candy-like substances are making those attractive to younger people, and it becomes confusing, and there may be some need to regulate that a little bit. Some of the vaping markets can use a lot of flavoring, which can appeal to younger people. I think some of those issues need to be examined to make sure that the protections for underage people using it and the attractiveness that's being marketed that may appeal to young underage people needs to be dealt with. Otherwise, I think you've got to take a look at where the black market is going right now and probably adjust the memo to take that into account and make sure that prosecution of the black market is stepped up, both state-wise and federally, because to me, the key to all of this is the maintenance of a legitimate and well-regulated business. That's how you're going to ensure public safety in this area.
And if I can add something from the FDA perspective, FDA has not issued any kind of formal enforcement discretion policy in this area, but it has obviously chosen what its priorities are, and it has not taken enforcement action against the medical cannabis market, against recreational cannabis products, by and large, except for products making extreme claims in the CBD and hemp area. And I do not expect FDA's enforcement priorities to change. And I know there's some fear among some in the industry that oddly, that kind of the rescheduling of cannabis to Schedule 3 would somehow make FDA take more enforcement. And I think that's extremely unlikely to happen. I do not see it changing FDA's priorities. And in fact, the rescheduling is an indication that the agency's public health, that the country's public health agency believes that cannabis is less of a public health risk than it had thought when it last analyzed the problem.
A quick follow-up from Chris too. Anyone want to take on the possible timeline from here on out? OMB back to DOJ, comment period, and all of those elements. Do you have a realistic timeline for when you think this rescheduling process would conclude?
I'll defer to Howard on that.
Yeah, so it's at the White House. You would think that it'll move pretty quickly, given that the whole world knows that they're looking at it. And it would be the strangest thing in the world if OMB all of a sudden were to reverse this. And so you imagine they'll do that pretty quickly. There'll be a comment period of, say, 2-3 months. And then there will be a final rule. I would suspect that I'd be very surprised if there were not a final rule this year before the administration ends, and probably before November. And that can be accomplished if the proposed rule comes out pretty quickly and if they work fast. That's not the speed they have worked in the past on this issue, but there is a greater sense of urgency. And then, of course, once there is a final rule, people can sue. And it's a big country, so maybe people will. There are questions of who would have standing and all that, which I'm not going to get into here. And then it depends on the election, but I don't see a heck of a lot of opposition, frankly, to changing from Schedule 1 to Schedule 3. Just some sporadic words from some congressmen, but there isn't really a strong opposition that I've seen.
Great. Sam, I'll unmute you here. He's got the next question, Sam Reisman.
Hello, can you hear me?
Yes.
My questions are for Howard and for Tahir, and they both sort of have to do with increased competition in this sector. For Howard, does the Schedule III reassignment sort of make it easier for pharma interests to develop cannabis drugs and to sort of get their foot in the door in the medical marijuana industry as it currently exists? And for Tahir, my question is, does the tax relief that we can expect from 280E that could be expected to give the MSOs a big windfall, are sort of the smaller operators concerned about what that does, you know, for their position in the larger cannabis landscape? Thank you.
So I can start with the pharma and then I'll turn over to Tahir for the business. There's disagreement among some about how this will affect the ease of doing research. But the fact is that in order for pharma to get involved, they would have to submit new drug applications and go through the process of clinical trials to get an approval for a specific indication of a drug. And they have not had any desire to do so in the past. And I don't think that environment has changed, you know, much at all. And the framework for doing so has not. So is there going to be a company that's going to want to put the money in to do the clinical trials to file a new drug application for one specific indication for cannabis, with lots of competition out there, and what would then be the follow-up steps? I look at that and I think, practically speaking, I don't see that happening.
Sure. And I would say my answer to that would be is that 280E is an industry problem. It's not a large company problem or a small company problem, but one that by removing it would have a positive impact on both the MSOs and the small companies alike. I think of my partner, Wanda James, who's the first African-American cannabis business owner in the country. And she's been unable to make a profit after being in business for 15 years because of how devastating the 280E is. So again, us having the ability to eliminate that allows us to be able to grow our business, make investments in our business and investments in our community. I would say yes. Yes, it also goes away for the larger operators as well. But it's not something that I think will. Again, I think for the sake of not letting them have it, it doesn't make sense to not let us all reap the benefits of what the positive impacts will be.
Great. I'm going to call on Natalie Fertig now.
Hey, everybody. Thanks so much for doing this. I was wondering, and I think this is probably a question for Mr. Cole. The Cole memo extended just to Department of Justice enforcement actions, if that's correct. And then there's been some instances over the past few years where other agencies have enforced federal law. There were a couple of situations where the Department of the Interior went into Native American tribal land and tore up medical marijuana plants. And then recently, Customs and Border Protection has been seizing cannabis from licensed operators in New Mexico. I was wondering if there's any way that the GOJ specifically could expand a new Cole memo to address those sorts of things, or if those memos would need to come from each individual agency separately.
Well, I think there's a couple of facets to that. One is any of those actions that you described, if they were to result in a prosecution, would have to go through DOJ. It's the only prosecutive authority in the federal government. There may be an enforcement action, a raid, a confiscation, something like that, which may have more of a technically civil component to it. And to protect against any of those, you would probably have to have some sort of multi-agency agreement about how to treat cannabis and to have some uniformity of that treatment. That can be difficult in the federal government to try and get that unanimity of thought, which is why the easiest way to try and deal with it is through Congress, to actually pass a law that regularizes it. But particularly if it goes to Schedule 3, I don't see it as impossible for all of the relevant agencies to get together and try to agree upon an enforcement structure and an enforcement restraint regimen that they could follow that might regularize this. Having disparate enforcement actions really isn't good at the end of the day for the industry. And the fact is that the industry needs to exist for public safety to exist in this space. So hopefully they will get together, but DOJ can't do it by itself.
And I'll add one point to that, which is that for an agency, for FDA in particular, and other agencies like it, DOJ is its litigator. So FDA can do things itself, like issuing a warning letter or deciding to approve or not approve a drug. But if it's going to take big enforcement, as in an injunction or a seizure, it has to go to court, and it's the Department of Justice that represents it in court, not to mention criminal referrals and things like that. So when I was there, even when there were policy decisions made by DOJ, even though they didn't technically bind us, they affected us because we knew that the DOJ was going to be our litigator.
Perfect timing. I think we have one last question here from Alex Halperin. There's been speculation about whether Schedule 3 would only lift 280E for medical-oriented operators. Do you see this as likely, and can you speak a bit more broadly as to how and when changes to 280E would take effect?
I mean, I'll give it an initial stab. I think 280E would affect everybody who is in the business because it's not just geared towards medical operators. It's geared towards anyone who is engaging in the business with Schedule 1 or Schedule 2 drugs. Making it Schedule 3 removes 280E from its application. When it will take effect is when the rule becomes final. And unless it is somehow stopped through a temporary restraining order or something of that nature in the courts, once it becomes final, that will take place. Probably the key, and I'm not a tax lawyer, but the key is going to be whether or not it becomes final in time for the filing of returns that would be impacted by 280E by each of these businesses.
Sorry, I meant there's just one more. Sorry in the chat. Chris just had one more question, piggybacking on Natalie's question. Customs and Border Protection could still seize a Schedule 3 drug at interior checkpoints absent a prosecution. I think that's the point, exposure outside the DOJ process.
That's true because when you're at the border and when people are trying to enter the country, that is fair game. Lots of things can be seized and lots of the protections for search and seizure don't take place necessarily at the border like they do in the interior of the United States. So that can still take place. The question is going to be, and again, when you are desiring on a general basis to create a legitimate industry that is regulated within the country, bringing marijuana in from outside the country can raise a number of problems with that, depending on its amount, its quantity, its purity, exactly what its purpose is going to be. So this becomes a complicated situation if it's just somebody's quantity, a small quantity of marijuana for personal use. Probably not the wisest decision on their part to bring it across an international border anyway. The whole system is designed to be regulated right now in each state, for everything to be contained within that state, for everything to be protected and sourced only in those states. Obviously, if there's some broader sort of legislation and regulation, it may allow more interstate transportation of it and commerce of it. But right now, I think it's sticking at it's all going to be contained within each individual state. And that would rule out the border seizure or allow the border seizures.
Great. We've gotten everybody in 30 minutes. Thank you everybody for such great questions. If you weren't able to get your question in here for any reason or had any problem with the chat function, please just email me. It's Andrea@abiassociates.net. or respond to the person you got this advisory from, and we'll make sure we get you in touch with the right people. Thank you so much to our panelists for joining today and giving such incredible background and information for these reporters. And anybody, if you have any follow-up, please just feel free to hit me up. Thanks, everyone.
Thank you all.